So the Article 370 case is back today in the Supreme Court, and it's going to be going on for a few days now here at the Apex Court. Now, as you know, these are the cases which are challenging the abrogation of Article 370 and the reorganization of Jammu and Kashmir into 2 union territories. Now, we had, before the court's winter break back in December, around from 10th to 12th December, there had been arguments which had looked into some of these constitutional issues and why, what the central government did back in the 5th and 6th of August, and then with the Jammu and Kashmir Reorganization Act, why those moves which were made by the government weren't exactly in line with the constitution, or at least how these petitioners have been arguing that. Now, today, however, we saw a very limited argument which was made by Dinesh Dwivedi on behalf of Prem Shankar Jha, who's a former interlocutor from Jammu and Kashmir, who's one of the interveners in this case. Now, that argument, and the limited argument, is that actually this whole matter needs to be referred to a larger bench of the Supreme Court. Now, why is Dwivedi making this argument? According to him, this case, as we know, is being heard by a 5-judge constitution bench headed by Justice N.V. Ramana. Now, he says that some of these issues which they're going to have to look at here have been addressed previously by the Supreme Court by 5-judge benches of the past, which are the Sampath Prakash case back in 1968 and the Premnath Kaul case back in 1959. Now, according to Dwivedi, the way these two judgments interpreted Article 370 was actually diametrically opposite. And there's a significant problem there because there's now a conflict between the way this court will need to interpret Article 370. And he says that to resolve that dispute, they have to have a larger bench which will actually look and see which of those judgments, whether it was the 1959 one or the 1968 one, which got it right. So what exactly is Dwivedi is saying is the problem there? So according to him, it's a very fascinating argument actually, and it's something which not a lot of other people are raising. Only one other party to this case is actually making a similar claim. They're continuing to argue, and they will continue arguing tomorrow morning. But what Dwivedi's argument for Prem Shankar Jha is that, look, Article 370, if you look at the sort of subheading, says that it is a temporary provision. That is something which the government and its supporters have used to say, yes, therefore it was perfectly okay to abrogate it. But what Dwivedi is saying is that, yes, it was supposed to be temporary, but not in the way which the government says. So according to him, if we look at the actual wording of Article 370, particularly subclauses 2 and 3, and then we look at the way the drafters of the Constitution explained how they'd put this wording and why they'd put this wording and what the objective was in the Constituent Assembly debate. So if we look at all of these things together, it's actually very clear that 370 was supposed to be temporary, but in the sense that it was only supposed to be the provision governing how the Constitution of India would work with Jammu and Kashmir till such time as Jammu and Kashmir drafted its own constitution. Now, that constitution came into force in 1957, and the Constituent Assembly of J&K, which had drafted that, was dissolved in that year. So he says actually that till that time, yes, you could have provisions of the constitution applied using Article 370. Till then, you could have laws passed by Parliament applied there. But after 1957, nothing of this sort was possible. And he says that therefore, what the government did, the central government did on 5th and 6th August with their presidential orders and then the Jammu and Kashmir Reorganization Act, he says all of that was illegal. Now, this is a very complex argument, and it's something which, as we said, not a lot of others are trying to make that one. It'll be interesting to see what the judges say, whether they'll agree to this reference or not. Dwivedi spent most of the day making his argument. He also pointed out that the other key thing which has been done with the abrogation of Article 370 is the repeal of that Jammu and Kashmir Constitution. And he multiple times took us back to whether it's aspects of the Constituent Assembly debates or the 1959 Premnath Kaul judgment, which seemed to indicate that Constituent Assembly and Constitution of J&K had to have a very status of primacy. And now, according to him, because of this status of primacy, it was not possible for the Indian Parliament here to just sit and repeal that constitution without having taken any steps which that constitution actually provided for, and use sort of provisions which were there in our own one. So that's obviously a debate which the judges will have to decide before they take the case forward. Keep following the Quints for all the updates as we go forward, including from tomorrow morning's hearing.